Assalamualaikum and hello to my lecturer, which is Sir Badrul Hisham bin Muhammad Siddiq, and everyone. First of all, let me start by saying a few words about my own background. My name is Muhammad Amirul Asraf bin Zulkifli. My ID number is KNJ 2005-100-178 and I am from section 2. As you can see on the screen, our topic today is to present and explain about question 1. In my presentation, I will focus on 4 major, which is issue, opinion, law, and half of application. Okay, let's start. Whether that provision can be included in contract of service agreement, because contract of employment is state that no employee is prohibited from establishing trade union is an agreement whereby one person agrees to employ another as an employee and the other agrees to serve his employer as an employee, and includes an apprenticeship contract. In my opinion, that provision cannot be included in the contract of employment agreement. To support my opinion, according to section 5 of Industrial Relations Act, it states that firstly, no employer shall prevent a worker from joining a union by putting a condition in his contract of employment. Just like Ali's situation, his employer put the condition in the contract of employment that state the employee can't join any trade union and the employee can't establish trade union at the work. Secondly, no employer shall refuse to employ a worker on the grounds he is a trade union member or officer. Employees have a right to join the trade union, so employers can't refuse that. Thirdly, no employer shall discriminate against a worker such in terms of promotion on the ground he is trade union member or officer. Lastly, no worker shall be threatened with dismissal or dismissed if he proposes to join trade union or if he participates in union activities. In application, that provision cannot be included in the contract of service agreement because it is against the provision Industrial Relations Act. Trade unions can't be registered. Then every application for registration or any association, combination or society as a trade union shall be made to the Director General in the prescribed form and shall be signed by at least 7 members of the union, any of whom may be officer thereof. So if Ali still want to establish a trade union, he should find one more member. I think that's all. Now I will pass to next presenter. Thank you.
Hello and Assalamualaikum. My name is Batrisha Syafiqah binti Badrul Hisham. I will continue application of the issue 1. Every application under subsection 1 shall be accompanied by a fee, printed copy of the rules that have been signed by the members of the trade union who have made the application and a statement of the following particulars such as the names, occupation, and the address of the members that make the application. It also includes the name of the trade union and address of head office, the titles, names, age, address, and occupation of the officers of the trade union, and such other information regarding officers as the Director General may in any particular case require to be furnished. For example, if Ali and his members want to establish a trade union, they must pay the fee, sign the rules, and make sure all of them agree with that, including the names, occupation, and the address. The conclusion of the first issue is the provision cannot be included in the contract of employment agreement because of condition that state in their contract of employment is unlawful. Okay, now we move to the issue 2, which is whether the registration of the trade union is possible because of only Ali and his 5 friends want to join the trade union. In my opinion, the registration of the trade union is not possible because of Ali did not enough requirement to join trade union. To support my opinion, there are a few requirements to register the trade union. Firstly, any worker over the age of 16 who is interested in joining a union that is relevant to his trade, occupation, or industry is eligible to apply. The term of workman is defined in the Trade Union Act of 1959 as any person employed by and under a contract of employment. Union members under 18 years of age restricted in their union activities, they are not entitled to vote on matters involve strikes, imposition of a levy, and the dissolution of the trade union or amendment of the rules of the trade union. Then, union members who under 21 years are not eligible to be elected as officers of the trade union. For example, if Ali and his friend did not reach the age that has been stated, that means they can't create the trade union.
Thank you for the previous presenter. Hi, my name is Mirza Afrina bint Abdul Rashid. So now I will continue for the issue 2, which is to support my opinion. Secondly, students cannot join trade union unless they are born free workers and over the age of 18. Thus, a worker granted student leave by his employer and who enrolled at a local or university would still be eligible for union membership. As a worker who is studying part-time. For example, if Ali and his members still student, then they cannot form a trade union because of insufficient condition. Thirdly, public sector workers can only join union formed by workers in the same occupation, department or ministry. The Inland Revenue Officer Union speak for the officer working in the Inland Revenue Board. For example, Ali and his member cannot establish separately a trade union if they are under the public sector. Lastly, employees of statutory bodies and local authority can join unions, but the membership must be confined to workers in the body or auditory. For example, Malay Teachers Union, and if Ali and his member are in uniform, then they are able to join a trade union. But if they are just auditory civilians, then they cannot set up. In application, the trade union cannot be registered because it not meets the requirement of the minimum members to apply for the registration. This is because the application for registration must be signed by at least 7 members, which is the minimum number needed to form a union. Other than that, the application form must be accompanied by the required fees and a printed copy of the rules or constitution of the union. Then, the application must include the name of the union and its address, the names, the addresses, and occupation of the member, making the application and the names, addresses, age, and occupation of the union's officer. The Department of the Trade Union may also require other information, such as a copy of the minutes of the inaugural meeting of the worker who wish to establish the unions. And lastly, the workers wishing to form a trade union must apply to the Director General of Trade Union for registration within 1 month of establishing the union. If the period of 1 month is insufficient, a request for extension of up to 6 months can be made to the Director General. As a conclusion, the trade union cannot be registered at this moment because of he did not enough member to establish the unions at the workplace. So that's all from me. So I will pass to the next presenter.
Before I start, I will introduce myself. My name is Fatin Asparina Najwa binti Muhammad Khairi. I'm the last presenter, and I will talking about 4 reasons for the distinction between a contract of service and contract for service. First of all, I will start with introduction of contract of service. Contract of service is an agreement whereby one person whose employer agrees to employ another as an employee, and the other employee agrees to serve his employer as an employee, and include an apprenticeship contract. This is a distinguished from a contract of service where the employer get the work done by independent or self-employer and contractor. An employee is described as a person who is subject to a contract of service, while an independent contractor is bound by a contract for service. This is to say, his obligation to do a certain job very much distinct from the more general obligation to serve generally within the scope of his class defined in his contract. Next, we move to the reason of the distinction between contract of service and contract for service. This is a compulsory statutory contribution and payment like the provident fund, social security, workmen compensation, and pension scheme are payable by employer if the worker are employed. For example, if any employee sign a contract with the employer, it means he or she is eligible to get provident fund, social security, workmen compensation, and pension scheme. Secondly, in that, an employee will not normally be vicariously liable for the total act committed by independent contractor, whereas the employer will be liable for tort committed by his employees in the course of their employment. For example, worker who sign the contract of service with the employer did not take responsibility for employees, but the contract for service, the employee will take responsibility for them if anything happened in the course of their employment. Thirdly, the employee of a duty at common law to his employees to take reasonable care for their safety, whereas these duties do not normally apply with respect to independent contractor. For example, such independent contractor are not required to strictly obey The law and their job are typically more easygoing and flexible. Lastly, in case of a judgment made against an employee, an attachment of earning can be ordered where the court can compel the employee to deduct the employee's salary and wage for certain purpose. For example, if the employee is at fault, then the employer has the right to impose a law on the employee, such as cutting wage. So, in conclusion of distinction between contract of service and contract for service, it is important to select the appropriate type of agreement that must be drafted between two parties in order for agreement to be legally binding. A faulty contract can be lead to dispute and a breach of term and condition agreed by both parties. I think that's all from me, from us, and thank you.